So let me get started. Welcome to the 33rd Annual Conference of the Adoptive and Foster Family Coalition of New York, Workshop 10B. The name of the workshop is Enhancing Foster Parents' Rights for the Benefit of the Children. I can't tell you how much I like the title of this workshop, because we need to enforce, not enhance, enforce foster parents' rights. And why do we need to do that? To benefit the children. So I was so intrigued by that. Before we begin, before I introduce Megan, I just wanted to remind you I'm Pat O'Brien. I'm the executive director here at the Adoptive and Foster Family Coalition of New York, and I'll be moderating this session today. I want to remind anybody who wants a training certificate, make sure you put your full name on the screen, or else we can't give you the training certificate. Also know that we have, if you're going to buy any books at all, please use our bookstore, because the bookstore is donating 15% of the orders to us. And they're not charging more money to do it. They're just giving us 15%, which is really, really cool of them. And then finally, I'm going to have you all fill out an evaluation form. So periodically throughout this workshop, I'll put on these links to these three items. All right, now, Megan O'Leary, she's the first-time presenter at this conference, and she's a certified adoptive parent, she's a foster parent, and she's an attorney. Megan graduated from the Maurice Deane School of Law at Hofstra University as a Pro Bono Scholar. Megan's career has been focused primarily on child welfare litigation, and she has experience advocating for each of the stakeholders within the system: the local child welfare organization, bio parents, foster parents, and the children. In 2018, Megan was certified as a foster adoptive parent. In the past 4 years, she has cared for children ages 2 months to 12 years of age with varying needs, and she is currently caring for a pair of 17-month-old fraternal twin boys. Megan joined Monroe County's Foster Care Advisory Board and looks for other opportunities, such as serving on the Coalition's Advisory Council, to help improve the system by sharing her experience and knowledge with other foster parents who are trying to navigate the complex child welfare system, always through the lens of doing what is in the best interest of children who are currently in the state's care. Magnificent. Megan, I'm going to turn it over to you, because I am just looking so forward to this workshop.
Thanks, Pat. I appreciate it. I like to thank everyone for joining. I know we were just talking, it's a Saturday. It's gorgeous outside up in Monroe County. It sounds like down in the city. People are in between games, but I'm hoping, we can kind of connect and find ways to, the way I look at it, fill in the missing puzzle piece when it comes to these kids and making sure that they're getting what they need. So let me just share my screen and then we can get started. 1 second. It's not letting me share. Oh, okay, hold on. All right, can everyone see the slideshow?
I can see it.
Okay, so I cannot see you while I'm giving this presentation. So if you can just speak up, that would help me a lot.
So Megan, would you prefer that if somebody has a question to just take themselves off mute and ask you the question verbally?
Sure, that'll
Okay.
work. And just as a disclaimer, so I'm an attorney, and we're taught that the answer to almost every single question is it depends. So if I don't know the answer, I can, try to talk through it a bit, but I'm happy to follow up with people afterwards too, depending on how things go. So, all right, a couple of things we're going to touch on today. We're going to talk about roles in family court. I feel like this is probably the area that most people are familiar with, but we're going to review it just in case. We'll do 10-day removal hearings and board rate cases and hearings. Throughout there will be some information on some class actions and other suits that have happened in the past couple of years as well. My hope is to talk generally, give you kind of information about the process, the systems, but then also give you some real practical tips for how to enforce your rights with or without an attorney. Okay, so the players in the family court system are obviously not the future Super Bowl MVPs that are pictured here, but there's the child or children, attorney for the child, parents' attorneys, the CPS caseworker, CPS attorney, which sometimes, excuse me, is an attorney who is either employed by the local Department of Social Services. I know some counties call it Department of Human Services, or it's a county attorney who has an agreement to represent the county, the county on these cases. Getting over being sick, so bear with me. And then of course you, and then possibly your attorney. Does anybody want to take a guess at who, if you don't have an attorney, who is there to advocate for you as the foster parent?
I would guess nobody.
Nobody, right? Or you, right? You're the only one. Sometimes foster parents will go to the attorney for the child and try to give their, give their arguments to the attorney for the child, thinking that this is what's in the best interest of the child. And foster parent might be right. It might be in their best interest, but it's not the attorney for the child's job to argue for the foster parent. Another option is to go to the caseworker or to the caseworker's attorney and raise your concerns. But of course, they're again not representing you as the foster parent. Okay, so one little bit of confusion that tends to happen in family court is the difference between attorney for the child and a law guardian. So it used to be that law guardians were assigned to basically represent or speak for the children in family court, and then it changed over to attorney for the child. The difference comes down to who is calling the shots. So an AFC, attorney for the child, argues for what the child wants, except for in 2 limited circumstances, whereas the law guardian would argue for what is in the child's best interest. Sometimes they still appoint guardians, but they don't play the same role as an AFC. So when I said that there are 2 circumstances where an AFC won't argue for what the child wants, that's what we call it, substituting judgment, right? So the attorney for the child is supposed to meet with the child, talk to them about what's going on in an age-appropriate manner, and then they decide from there whether they're going to go in and argue for what they want, which should be the default and almost always happens, or if they're going to substitute judgment. So there are 2 times when they can substitute judgment. It's written in 22 NYCRR 7.2. It's when the attorney for the child's convinced either that the child lacks the capacity for knowing, voluntary, and considered judgment, or that following the child's wishes is likely to result in substantial risk of imminent serious harm to the child. So 2 separate things: harm, or they're not capable of coming up with this decision on their own or really understanding the decision that they're making. Does anybody have any examples of when that's happened in a case of theirs? Or can you think of something that might cause a child to not be able to come up with that decision on their own? One second. Oh, shoot. So I'll give some examples since I can't call on anybody, but it's if the child's too young, that can play a role, right? So if it's a 3-year-old saying, I want to live with mommy, they're obviously not to the level of figuring out a schedule, what schedule works for them, understanding their needs. Excuse me. If sometimes there's parental alienation going on. This, theoretically can also happen with foster parents. If there's parental alienation going on, that's kind of, somebody is really influencing this child to ask for one thing or another, the child's not being honest about their needs, then that's another way the attorney can decide that, okay, this child's not really coming up with their own decision, so I'm going to have to substitute judgment and figure out what's in this child's best interest. So as a little bit of a background, when I first started practicing family court, I was doing AFC work, and it was our office policy to substitute judgment as little as possible. And the reason for that is because, we're giving the voice to the child. There are going to be other people who are going to come in and make these arguments about whether the child is capable and at risk. But we tried as much as possible to bring in the child's voice. Even when you're substituting judgment, you're supposed to advise the court of the child's actual position, but only if the child wants you to do that. There's some times where a child, might tell the AFC, like, I want to live with mom, but don't say it in front of dad, right? So that makes it a little bit tough as far as being able to advise the court on their actual position, if you're substituting. There's also one time where you never substitute judgment, and that's in juvenile delinquency cases. In those cases, an AFC is looked at as basically a defense attorney. And so you zealously advocate for what your client wants. All right, and then, so I put don't confuse with strategic omission. So there might be times where, as a foster parent, you hear a child talking to their attorney, or the child tells you afterwards what they're talking about. Obviously, don't go asking the child what they're talking to their attorney about. Don't try to influence them. But then you get into court and the AFC doesn't bring it up, right? And you don't know why, and you think it's important. Sometimes it can be part of strategy, right? So you might, depending on the issue, you might not want to let on just yet, or they might be handling it another way. They might not have had enough time to gather the documents that they need. Sometimes, as an AFC, I've had cases where there was abuse or neglect going on. It was a custody case, but kind of hard to prove, right? So we were gonna eventually need to file an emergency order, but the child was living with the person, and we needed to wait until we had enough for the judge to sign off on basically changing custody temporarily. And that's not something that a judge is going to do easily. So, it wasn't something we could just argue right away. So there is some strategy that goes into it that might not be obvious from the get-go. Also, when it comes to talking to the AFC can speak with you, but they don't have to, right? And if you're represented, they actually can't speak with you unless they have your attorney's permission to speak with you. As an aside too, I wanted to say, like, you are entitled to an attorney. You can retain an attorney. You can have an attorney with you at court appearances. Okay. So I disagree with the AFC's decision to substitute. So what do you do? I kind of touched base on this a little bit, but you can try to talk to the AFC. You can go to, depending on the issue and who might be on your side, you can go to one of the parents. You can go to the parents' attorneys. You can go to the caseworker or the caseworker's attorney. You can also speak up in court. Or at service plan review meetings that happen outside of court if it's an issue with the services the child's getting in place. The problem is, so if you speak up in court and you say, this AFC is substituting judgment, this is not what the child wants, of course, natural human tendency there is that you're probably going to upset the AFC. But there are times where, it might need to be done. Something might need to be brought to the judge's attention. Ultimately, a party could file to have the AFC removed. But to be honest, I've been doing this for 6 years, going on 7 years, and I've only had one case where I've threatened to do that. And we actually did not end up going that way, where I've threatened to do it in court, and we've actually not ended up going that way. Okay. So, right to notices and reports. You have a right to permanency planning hearing reports and notices. You're entitled to the report if a child is currently residing in your home. I'm not sure how long everybody's been fostering for, but when a child's removed, approximately every 6 months, depending, there are permanency planning hearings where the court reviews the services that are in place for the parents and the children. They look at the goal, which in the beginning is return to parent, almost always. After a certain amount of time, that can be changed to adoption. And they look at whether or not the county has made reasonable efforts to meet that goal, to help the parents or the family alleviate whatever issues they had in the home that led to the removal of the children. So there's a report that kind of summarizes all of that. It's drafted by the county. It's supposed to be distributed at least 14 days prior to the permanency planning hearing. And if a child's currently residing in your home, you have a right to that report. Sometimes it comes in handy. Like I just had I took in 2 kids recently, and they have some pretty substantial needs, medical needs, appointments, providers that were in place before they came to my home. And so I was pretty diligent about asking for that report, because normally those services would be detailed in the report. So in case somebody forgot to kind of pass the information along, hopefully it's in there and I can follow up that way. So you're also entitled to notice of the permanency planning hearing date if a child previously lived in your home for 12 consecutive months. So you can appear at those court appearances. You're not necessarily going to get a copy of the report, but you can appear. That can be important, down the line if there's an issue with the current placement, and they might be looking at, somewhere else to place the child, or if they're looking towards adoption. So another notice, and we're going to get into each of these separately in more detail, is you should get a 10-day notice if the county plans to move a child for any reason, and then from your home. And then you should also get a notice of the board rate that you'll be receiving for a child. Okay, so first, talking about the 10-day notice to remove. The notice has to be in writing. It has to be sent at least 10 days prior to the move. Obviously, if there's an emergency, they're not going to leave the child in your home and give you 10 days to further hurt the child or whatever is going on, right? So they can remove the child immediately without giving you notice if the health or safety of the child requires it. In the notice, they're supposed to advise you of a right to a conference, as well. That should say as well as your right to a hearing. And then you can waive the 10-day notice, but it has to be in writing. Your waiver of it has to be in writing, and it has to be after the county has already made the determination that they're going to remove the child from your home. So if they come and they say, okay, we're removing this child, we've made this decision, we're removing the child, and you sign off saying you don't require the 10-day notice, then they're not required to give it to you. Okay, so 10-day notice to remove continued. If you request a conference, so once you get that notice that they're going to remove, you can request a conference. They have 10 days to hold the conference from the date that you request it. Typically, the child will stay in your home while that decision's pending. So they hold the conference 10 days later. Decisions issued 5 days after that, maximum 5 days after that. It has to be in writing, and it has to advise you of the right to a fair hearing. Child cannot be moved for another 3 days after the decision, right? And the reason for that is probably so that you can go ahead and request your hearing and try to prevent the child from moving in the meantime. The county and the foster parent might come to an agreement on how to resolve the matter. Maybe it's, they don't move the child right away. Maybe they do. In any agreement, it has to include a list of the rights that we just went through. That just to make sure that you're aware that you have, those options. Something that gets a little bit tricky. These don't get appealed very often, right? And we're going to talk about the board rates in a minute, and those also, depending on the county that you're in, those don't get appealed often. That might be because of a couple reasons. It could be that the county is automatically giving the right board rate 100% of the time, and there's nothing to appeal. I doubt that. It could also be that foster parents don't realize they have these rights, so they're not getting these notices, or they're not reading them. So one thing for this that I've seen happen, I've actually only seen it once, where on a case that I've been involved with, where somebody has challenged the removal. The child was moved in the meantime, and then you kind of get to a point where, okay, so you challenge it after the fact, but at that point, what's in this child's best interest? There are different reasons for removal. The children are being returned to their parents by court order. That can be on a trial basis or permanently. It could be sibling reunification. So, if a family of 6 kids comes into care and the county doesn't have a place to house all 6 kids, or they have, 3 here, 2 here, 1 here, and a home opens up that can take either, that can keep more of them in the same home, if not all of them, they might move them all together. Placement in kinship care, so relative or a resource, by court order. So it might be, you might be in family court, and family court could say, okay, you're moving these children because of whatever issues the bio parents are raising against the foster parents, or because of whatever the case status is at that time, right? Kind of going along the lines of one of the ones we already talked about. So health and safety concerns, which we talked about, inappropriate discipline, unsanitary household conditions, failing to keep medical appointments, allegations of maltreatment or abuse, which require an investigation, failure of the foster parent to comply with technical requirements. I know when I did my training and my research, we were told that if you fail to get your stuff in to recertify, and your home, you pass that recertification date, the children are moved immediately, because they can't be in a house that's not, in a foster home that's not certified. Inappropriate placement, the child needs a higher level of care, or the foster parents cannot meet the permanency goal of the child. Another thing that, maybe this goes along with inappropriate placement. I think it would, under cannot meet the permanency goal. So, as if the county is working towards reunification, which it almost always is in the beginning, and a foster parent is kind of sabotaging that sort of reunification, and there are different levels of that, then that can cause children to be moved. And actually, I've heard of cases where children are moved and then the home is closed because of it. An interesting thing to note, you actually don't have an option for challenging the county's decision to close your home. It's looked at as they have the option to hire who they think is appropriate to to care for the children. And if they decide that they don't want or need your services, that decision's totally on them. All right, so requesting a removal hearing. So you give your 10 days, you have your 10 days to request a conference, but you have 60 days to request a hearing. Your request has to be made in writing. The address is there. This is also on the OCFS website. These hearings specifically are done through OCFS. The other hearing that we're going to talk about is done through OTDA, the Office of Temporary Disability Assistance. They have sort of a working relationship where OTDA handles some of their hearings, but these ones are handled by OCFS. Okay, so do you need an attorney? This isn't a normal court hearing like you're used to when you go into family court. It's pretty informal. You don't need an attorney. You can have an attorney if you want one. You can also have somebody who's not an attorney represent you. That's the case for, I want to say every administrative hearing, but I don't know that. But the ones that I've done, that's been the case. So unemployment insurance, if you're appealing a decision on that, if you're appealing a benefits denial, if you're, the hearings that we're talking about today, those, you don't need an attorney, but you can have somebody represent you who's not even an attorney. I actually started doing them when I was in law school still. I was able to represent people and I wasn't even out of law school. So if you're nervous about talking and your sister does a better job, then she can go in and speak for you. You can review the county's case file. They send you copies, relevant portions of it, whatever they're submitting as their evidence, they should be sending you a copy of that. So standard of evidence, that's something that, a phrase that we use in law, and it's basically, you hear about in criminal trials where it's beyond a reasonable doubt. You have to prove it beyond a reasonable doubt. So here, it's not that high of a burden. The standard of evidence is preponderance, so it's more likely than not, right? So 51% chance that what the county is saying their concerns are actually valid. That's what they would need to prove. Do the rules of evidence apply? So, it's funny, we get into court and a lot of people like to throw around the word hearsay. Matters in family court doesn't matter so much in these administrative hearings. So you can get in, records that aren't necessarily, like medical records that aren't certified, right? Whereas if you didn't have them certified in family court, there would be issues with those records coming in and being considered by the judge. So the rules of evidence don't really apply here. Basically anything that's relevant and reliable, that's what the court's going to consider. So, or the hearing officer is going to consider. Can you subpoena witnesses and records? Yes. You can reach out to the ALJ, that's the administrative law judge, for subpoenas to have witnesses appear to testify and to get records that you need if you're having trouble getting them. So and then another thing that I find representing parents that happens a lot, they kind of say like, well, I don't have any evidence. You can testify too, right? So your testimony is considered evidence. So if you have something, if you want to tell your side of the story, that's considered evidence. Okay. Okay, so removal hearings, what if I win? What if I lose? If it's close in time, and you win, the child will remain in your home or be returned to your home. If it's far enough out, then the county's got to consider whether or not that's going to be good for the child at that point. If you lose, you can appeal it through an Article 78. But that, to be honest, is a lot of time, a lot of money. And I can't imagine a scenario, I haven't seen it yet, where it would make sense to go that far with this. And at that point, I would highly recommend getting an attorney. They're very complicated. It would take me a ton of time now to figure out what to do. Okay.
What is an Article 78? You can appeal it to an Article 78.
So it's the process to challenge an administrative decision or an agency decision. So if an agency is not acting the way that you want it to, you can actually bring it into court and have the court order them to fix it. The fair hearing is still within the agency, right? It's still an administrative hearing. Once you go Article 78, it's beyond that at that point. To even do that, though, you have to go through the fair hearing process first, because you have to exhaust any administrative remedies that you have. Which actually reminds me, you don't have to request a conference. You can request a conference, though. So you could skip the conference part of it and just go straight to the fair hearing. Or you could do the conference and get information on, why they made the decision, have a chance to talk to them and see if they can, kind of change their mind about it. And then from there, decide whether or not you want to go through with the fair hearing. Fair hearings also, just so you know, they don't cost anything. So depending on the situation, you might have nothing to lose other than, the anxiety that comes with sometimes the confrontation, right? And having to read, I mean, if it's a removal hearing based on inappropriate care, you're going to get a case file with all of these notes about things that people have said about you, things that they think you've done. And sometimes that can be, I would imagine, be difficult to read as well. All right, so foster care board rates, moving on to the next topic. Does anyone have any other questions about the removal hearings?
Somebody did have a question in the chat box. Can I read that to you?
Please, I can't see the chat box.
Okay, good. I said, this is not directly related, but it's similar. Do foster parents have the right to review any past court meeting reports related to the child in their care prior to them being placed in their care?
No, but that doesn't mean that people won't talk to you about that information. So I would suggest talking to the caseworker, talking to the attorney for the child, seeing, what information you can get from that. Also, sometimes when kids are coming to you, they're not coming to you, they're coming from another foster home, right? So sometimes if you can get in touch with the former foster parent, you can get information that way on what's happened before. The permanency planning reports, depending on how detailed they are, I've seen a wide range of detail on these, sometimes bare minimum, sometimes every little detail. You can get information that way because that goes back for 6 months, and does have kind of the history, some of the information about the removal, why it happened. It'll be general information, though. You're not going to get specifics normally. But so those are some ways to kind of fill in the gaps. And then obviously talking with providers, seeing if you can do that. And if there's a specific issue that you feel like you're not getting clear answers on, and it's going to impact things going forward, you can, at a permanency planning hearing or at a court appearance, you can certainly bring it up and try to get an answer during the appearance.
Megan, do you see a person has their hand up? Can you see that, or should I call on the person?
Can you call on the person, please?
Okay, Antoinette has her hand up.
Yeah, good morning. Good morning. I have a couple of questions. One is with regards to the 10-day notice. There are times when I've had foster parents say that the 10-day, they removed the child and then gave them a 10-day notice. And given the circumstances of why the child was removed, I didn't understand that it wasn't imminent danger or anything that the parent had done. And then they asked them to sign to say that they've been given the notice. And that was after the fact. So that's one of the questions I have. What ramifications or what rights do they have at that point?
Yep. So if they're just signing saying they've been given the 10-day notice, that's not really making too much of a difference, other than like your time to ask for that hearing starts when you're given the notice, right? So by having the foster parent sign, there's not going to be a dispute over whether or not they received that notice on that date. But you still have your 10 days to appeal it. And certainly, you'd want to bring that up at the fair hearing that it wasn't imminent danger, and none of the other reasons for removal apply. It's also something that, you could call the AFC about, right? Depending on who the AFC is, and you could call them. You could, depending on your relationship with the bio parents. I had a really good relationship, or really good relationships with two of my placements, their bio parents. And if something were to happen with the kids moving from my home, I'm pretty sure they would have been talking to their attorneys about getting into court and changing that, right? Obviously, unless it was moving back home to them. But if it was to another foster home, they would have been not happy about that. So, those are, you're still getting the 10-day notice. You can still ask for the hearing. The issue of whether or not it was an imminent risk is something to bring up. And luckily, the timelines there are pretty quick. So if you get the request in for the hearing sooner, you get that ball rolling, and hopefully the child's not removed for too long.
But it seems like but then they lose the opportunity to have that grace period to have the child not removed. What if they already removed the child and then ask the parent to sign?
Yeah. Well, so you're saying they sign though for just saying they received the notice, right? Or are you saying they sign?
I think that they, I guess parents are hesitant, because I would be hesitant also to sign something that I received after the fact, because it's a 10-day notice that the kid is already gone.
Yeah.
Right.
So I think that there's some issues around that. Why would they have to sign it at all?
Yeah, you don't have to sign it. You don't have to sign it. You're not required to sign anything. But whether they give you the 10-day notice or not, or they have you sign or not, your course of action there is to request the hearing.
Okay. Now, the other question I have is with regards to foster parents' ability or to have someone with them in the proceedings to speak if they're not, able to articulate or they're too emotionally involved. I've had a personal experience with a judge. I simply said, if you're not an attorney, I don't want to hear from you. So why would, in that instance, they didn't allow that parent to have representation at all, because you couldn't say, and it wasn't confrontational or anything. He just started right off from the back. Who are you and why are you here?
Yeah. What kind of court appearance was that?
It was with a fair hearing case.
It was a fair hearing case?
Yeah.
Okay. I don't know why that happened. You don't have to be an attorney to represent somebody in a fair hearing. So what recourse would you have if that happens? What would you don't want to offend the court, you don't want to challenge or be combative with them, but at the same time, how do you stand up for the rights of the foster parent if they're telling you you can't say anything? were they telling the foster parent they couldn't say anything? Because those, I mean,
No, they told
okay,
the representative or the person there, why were you here? And if you're not an attorney,
right.
they mute you out of the Zoom or whatever, and they don't want to hear from you.
Okay. So I don't know that answer off the top of my head. It shouldn't have happened. You're entitled to have somebody represent you in those, even if you're not an attorney. I thought you were going to say, honestly, that it was in family court where you would have to be an attorney if you're speaking for somebody else, but a fair hearing, you don't need to. I'd be happy if you want to send me your contact info. I can, kind of look into the issue, but I don't know the answer off the top of my head.
Okay, thank you. That would be great. Okay, and what was the other one? I had another question, but it may be a little bit more complicated because it deals with.
That's it. Hang on for a second. Megan, do you want to go through the presentation and then answer the questions, or do you want to take the questions as we go along? Because it might take you off what you wanted to at least get out there in the universe.
Yeah, let me do that. Honestly, I didn't I didn't think I was going to have enough material, but it looks like I probably am. So let me go through the rest of it and then I'll answer questions.
I only asked because you said, any questions?
Yeah. No, I know. That was
And
I'm happy to
Antoinette
take
is the coalition's advocacy person. She advocates on the behalf of foster families on a case-by-case basis, and she's also a former advisory council member. So we will get back to you, Antoinette, but let's let Megan finish.
No problem. I understand. I appreciate that. Okay.
Perfect. Okay. I'm really excited about the next section too. So I really want to make sure that we go through this. So foster care board rates. Thank you to the coalition for the work that they've put in. If you don't know, there was a lawsuit filed 11 years ago, 11 years, and it was just settled within the past year. Some of the big things that came from that are the initial board rate is going to increase up to 46%. Depends on different factors like where you are, whether we're talking about the normal or the exceptional rate, things like that. And then this one I think is huge. There's an annual adjustment to keep up with inflation, right? So they're going to be reviewing these rates every year and changing them, whereas that hadn't really been happening before. Basically, the federal law says that these board rates have to be enough to pay for the needs of the children, and because these hadn't been increasing at an appropriate rate, they kind of fell below that. And so because of the work of the coalition, we're getting back there. It's great, but within that, there's the normal, the special, and the exceptional rate. So you need to make sure that you're getting the correct rate within those three. All right, and back to talking about notice. So when a child comes into your home, you're supposed to receive a notice of the board rate that you're going to be getting for that child. So this is a picture of the form, part of the form. You'll see it's got check boxes for normal, special, and exceptional. It's got a spot for them to write the board payment there, the date that it's effective. And then you'll see at the very bottom in capital letters, you have the right to appeal this decision. Be sure to read the back of this notice on how to appeal this decision. So summarizing the back of the notice says that you must request a hearing within 60 days from the date of the notice. What if you don't receive a notice? So say, you just start receiving the normal board rate, but you think this child requires the special rate, and we'll get into what qualifies children for the special rate and the exceptional rate in a second. But if you receive a notice saying we're giving you, the normal rate, you have 60 days from that notice. If you never receive the notice, that 60 days does not start running until you receive it. I can tell you right now, I have not once received this notice. So technically, even, the second question there, what if the children no longer live with me? I can appeal board rates for kids that I used to have in my home that I no longer have because I never received that notice. So my 60 days isn't up yet. Again, you know, if you get this, you're entitled to copies of the relevant parts of the child's file if you end up requesting a hearing. So let's look at what qualifies a child for the special board rate. That's, you know, the middle rate there. So this is listed out in the law. It's also listed word for word, taken from the law in that notice on that first page that I showed you. So if a child suffers from pronounced physical conditions as a result of which a physician certifies that the child requires a high degree of physical care, they qualify for the special rate. So it's not enough for you to go in and say, or for a teacher to go in and say, yeah, this child requires a high degree of physical care. It has to be a physician who certifies that. And then the special rate would go back to the date that they're certified as requiring that high degree of physical care, right? So if a child's been in my home since January, but in March they were certified as having that condition, then I could request that the payments be increased to the special rate back to March. Another way they qualify is if they're awaiting family court hearings on PINs or JD petitions, or have been adjudicated as PINs or JD or juvenile delinquents. Excuse me. Third way is they're diagnosed by a qualified psychiatrist or psychologist as being moderately developmentally disabled, emotionally disturbed, or having a behavioral disorder to the extent that they require a high degree of supervision. So again, keep in mind that it's got to be by a qualified psychiatrist or psychologist. Refugees or Cuban or Haitian entrants who are unable to function successfully in their communities because of factors relating to their status. And that can be something as simple as not being able to speak English or just not being able to relate to peers their age because of what they're going through. Another one is they enter foster care directly from inpatient hospital care. So that case, I had a child placed with me who was hospitalized and received inpatient care for, I think, at least a week. It was a few years ago now. And when he was discharged into foster care. And then he spent a month or so at an emergency foster home, and then he came to me. So I ended up appealing that decision because I was only receiving the normal board rate for him. I appealed it, and at the hearing, they overturned the agency's decision and told them that they had to provide the special board rate for at least a period of a year. Once that year is up, that board rate can go down to the normal rate, or the county can decide that they fit under one of the other categories that we've just talked about, and continue the rate at the special rate. And then there's kind of a catch also, like in the judgment of local social services commissioner, the child has a condition equivalent to one of the above. These can be made on a case-by-case basis, or each county might have a document that kind of lists out or a policy that lists out what conditions they would consider a child to automatically qualify for the special rate. The exceptional rate, so the highest rate, there are certain things that qualify a child for this. So required as certified by a physician, 24-hour-a-day care provided by qualified nurses or persons closely supervised by qualified nurses or physicians, right? So not 24-hour-a-day care provided by you. It's got to actually be by nurses or people working under the nurses. Or they have severe behavioral problems characterized by the infliction of violence on themselves, other persons, or their physical surroundings, and who have been certified by physician or psychologist as requiring high levels of individual supervision in the home. So again, physician or psychologist have to certify this. And some of these things, so a child might come into your home and not qualify for these when they're first placed there, and then you know, or you might not have the things you need to show that they qualify. and then that changes as they're with you. What you should do is put in writing a request for a higher board rate, and then have the county will either end up granting it or denying it. From there, you can appeal at that point. Okay, so a couple other qualifiers. The child's diagnosed as having severe mental illnesses such as child schizophrenia, severe developmental disabilities, brain damage, or autism. So this one I have also appealed under because I had a child who was diagnosed with autism placed in my home, and he was only receiving the normal rate. His behaviors were pretty challenging, but when I was looking up the cases, it does not matter how challenging or not challenging the behaviors are. If they're diagnosed with autism or child schizophrenia, they qualify no matter what their behaviors are, no matter where they are on the spectrum. They qualify on the basis of that diagnosis alone. So another one is diagnosed as having AIDS or HIV-related illness. And then similar to the special board rate is having a condition that is equivalent, that the county has decided is equivalent to those listed above. Okay, so request a board rate hearing. This one is through OTDA's website. I put the link there on the bottom, otda.ny.gov/hearings. You could just do /hearings, or to actually get to this form, it's /hearings/requests. So you can submit a request online, mail or fax. Sorry, that should be mail or fax a printable form. You can do it by phone, or you can do it in person in New York City or Albany. This is the form, the online form. It's super basic, easy to fill out. Obviously there are only a few required fields. And then they have your lack of availability when you cannot participate in a hearing, and then the name of the person requesting it, so your representative if it's not you, and then the reason. Hold on one second. So you can put in comments there about why you're asking for the hearing. So when I requested my hearing, it was 1 or 2 sentences. I should have received the exceptional board rate for this child from this date to this date. Okay, there is a fair hearing archive on the OTDA website. You can find similar cases and provide them to the judge during your argument. You just want to watch out for unrelated issues. So it works kind of like a Google search. The way I do it, I put my county, so Monroe, in quotes, and then I do capital letters and then I put in quotes either foster care or exceptional rate, and then you can filter by date and then search, right? And so it'll come up with other decisions in my county that have that. If I don't put Monroe, it'll just come up with the cases that deal with exceptional board rate. You'll find that there are quite a few cases that settled, and so the caption of the case is like based on agreement or something like that. So if you wanted to filter those out, you would, when you're searching, you could put in quotes decision after hearing, because that's language that's in the cases that actually go to a hearing. And so you can kind of read through those. You can type in other buzzwords, I guess, that you think are relevant to your case if you're trying to find something similar. Of course, it gets difficult though. Like, so when I was searching, I added the word autism, but that was in almost every single case, because what they do is they list out the language that, of all of those ways a child can qualify for the exceptional rate. The unrelated issues, there are sometimes you'll get cases that come up that are like, that have to do with benefits because they count or don't count foster care payments. And so that language will be in there and it'll search those cases. But if you can find a case that's very similar to yours, so when I was doing mine, I found some that said even a mild autism or something along those lines qualified a child for the exceptional rate. So they made it very clear cut. I was able to provide that to the judge when I had my hearing. Okay, so I just wanted to discuss a little bit why we request a fair hearing. You know, I was worried. The fair hearing I did for the special rate and the exceptional rate, it was actually one hearing. It was one placement, just two different kids. So when I did it, I was worried that, you know, I don't want this to come across as me being out there for the money. It's not what it was. And I think there can be that kind of stigma, right? Like I'm going and asking for more money, but does anybody have any idea why it's important to ask for the increased board rate?
Services go with the rate?
Yeah. Yep. Services go with the rate.
Right.
There have been a lot of studies that show that it increases retention of foster parents. It reduces the amount of moves for children, you know, and every move we know is a traumatic experience for a child. It's been reported when there's been an increase in services and stipends that there are fewer reported behavioral challenges. The interesting thing is that even without the increase in services, an increase in stipend alone led to these same benefits. You know, and I'd ask you don't have to answer out loud, but like think of ways that you could have used the additional financial support, right? So when I had the child in my home who qualified for the exceptional rate, he unfortunately did have to move for a period of time because I'm a single foster parent, right? And I really needed somebody else in my home at certain times, specifically in the mornings, to assist me with some of the behaviors, especially because I had the sibling in the home that I needed to attend to as well, right? If I had that additional financial support, I would have paid for somebody to be there every single day, right? And that would have kept those kids together. It would have kept him from moving. It could have, you know, if you have multiple siblings, you can have somebody come in to occupy them. So each sibling gets one-on-one time. You can use it. You don't have to use it on the kids. You can use it for self-care, prevent burnout, you know, and other things like that, which again are going to increase stability, hopefully increase your willingness to continue it. There's this site with a few other, actually quite a bit more information on studies. There's also things about like increasing the rates have increased the amount of homes, of minority homes. So like, you know, there's an overrepresentation of Black children in foster care, but now like increasing the amount, at least for younger kids, allows these children to be placed with people who are the same race as them. For some reason though, that tends to fall off after, I think it was 12 years old. But there are other benefits like that might not be immediately apparent. So all of these things kind of together is why, you know, we name the presentation what it is, enforcing foster parents' rights, because at the end of the day, you're the one who, you know, no one else is going to ask for the correct board rate if they're not receiving it. The AFC is not going to do that. The county's already made the decision on what they think it should be. The parents' attorneys have no interest in that, right? So you're the one that has to kind of enforce that and make sure that you and the child are getting that.
Mary Rothwell Davis, were you going to say something?
No, I was just going to chime in on the issue of services, and I wondered if it might also be helpful when it comes to things like an IEP to have, you know, show that the child has been certified in foster care as having these needs. That was my thought.
I'm sorry, can you ask it again? Sorry, I don't-
It was back on the issue of why would you, why is it important to have the additional rate? And I think Antoinette said services come with it, and Pat was asking what I would say. And my only other thought was it may also provide additional documentation when it comes time for an IEP and that sort of thing. I mean, the more that you can document and support the child, the better.
Yep, that's right.
Fairly straightforward thought. Thanks.
Yeah, it makes sense, but yeah, it makes sense. It's just kind of coming at it from a different angle, I think, than we're used to, because we don't have anybody else, you know, we don't have the county telling us like, hey, we're going to give you the normal rate, but you know, you should ask for this hearing and get the exceptional rate, you know. So
Right. So it's about a lot more than just the money.
yeah, for sure.
Thanks.
Anybody else? I think
So I could read a couple of things in the chat if you want.
sure.
And just for your own knowledge, Megan, Mary Wathwell Davis is an attorney that's assigned to us through a very cool law clinic at Fordham University. So she's a volunteer for the coalition. So thank you for your question, Mary. Amy says every foster parent should know their rights, understanding the legal system. Thank you for this wealth of information. Okay, that was a comment. Thank you, Amy. Can Megan put her email in the chat, or is it in the conference information? I don't know if you have access to the chat, Mary, but somebody was asking for your email. Oh, and here's a concrete question. Would ADHD be considered for a higher rate?
So not by itself. It's got to be one of those. If you go back to the things that we listed out and just go step by step and see if it's, you know, qualified by the right person or certified by the right person, and if it, you know, meets the 24-hour care or whatever the other requirements are in there. But ADHD, I do not believe falls under that alone.
Yes.
Sometimes, you know, you'll have other diagnoses along with the ADHD that might, but normally not by itself.
Was there anything else that you were presenting, or can we just go into question and
No,
answer mode?
Yeah, just question and answer.
Okay. I was fascinated. Go ahead.
Can I, for the ADHD, I'm a supervisor in a county, and we have done a special board rate for that. But what we have tried to do is document the extra support that child needs, or particularly highlight that the child's ADHD requires medication. So showing that there is a significant interruption in that child's daily functioning or ability to cope in school, and thus the kid needs supports. So that's what's worked in my county. I don't know about other counties.
So I really appreciate that that approach, right? Because there is, you know, under both the special rate and the exceptional rate, there was that catch-all where the county can decide, okay, we are going to consider this to be a condition that needs the special rate or the exceptional rate, right? So I appreciate that. It sounds like in your county, you guys you're open to expanding who gets that to make sure that these children are getting the support that they need.
That's right. I was fascinated to hear that there is a fair hearing archive that you can see how the past cases were. And you mentioned that you put in your county, but isn't the fair hearing system like a statewide system? So if there's a similar issue in a different county, wouldn't it sort of apply as well?
Yes, so you can use any of the cases statewide. The reason I put my county is because I actually first was searching for it while I was in discussions with the county before asking for the fair hearing. So I was hoping that there was a Monroe County case where they were already overturned on this. So I could say, hey, you know, instead of us going back through this going through this entire process, like you just had this case where the court told you that autism qualifies a child for the exceptional rate. Remember, like, here's the decision. What's funny is that, not funny, but is that very few cases came up, which makes me think that, again, those notices haven't been going out because there have been no hearings on it. So.
All right, so what are people's questions? This is it's a great opportunity. In
Yeah,
regard to-
so,
Go ahead,
hi,
Carson.
Pat. Hi, Pat. This
Hey,
is Tara
Tara.
again.
Yes.
This is such a great conference. So Megan, thank you so much. Your presentation was very, very concrete. Really appreciate it.
Thank you.
And just on behalf of Team Westchester County DSS, we really appreciate all the information and also the resource parents and allies on the call. My question is a little bit more abstract, with apologies in advance, as I help lead DSS's planning, policy, and program development team. You started off the presentation about sort of the nuances between the law guardian and the AFC, best interests of the child or young person, because we're not children in perpetuity, and also the law guardian that is about, I'm sorry, the AFC, what does a child want versus the law guardian. And then Ms. Antoinette talked about the experience of a judge who unfortunately sort of silenced, had an experience of being silencing. I wonder, as a fellow attorney, what have you learned over the years about building relationships and building trust with the court, with the AFCs, with the law guardians, and also with, experienced child, youth, family welfare practitioners, because obviously these resource parents are getting, have a relationship with their local DSSs. So I'm curious to know what you've learned that has worked well and hasn't worked so well. And I will applaud you. At no point in this conversation did you say it depends.
Thanks. Man, okay, so I worked well as far as building trust. I think being real about what you're struggling with as a stakeholder, and realizing it's nobody's fault necessarily, and everyone's kind of, at the end of the day, wants what's best for the child. Normally wants what's best for the child. We're just coming at it from different angles. And I think going into it with that mindset, of course, like I've had the luck, I guess, of representing all different parts of this system. The only side I haven't been on is actually, being a judge or working in the court. But so I can see kind of some of the struggles from those angles, and that helps me a little bit. But I think I know I'm kind of rambling right now because it's a tough question to give a direct answer on. But just being honest with the struggles and giving grace to other people in the system, because it's not easy. The issues are not easy, no matter what side you're on.
And that's a very good point. In the 6 minutes that we have left, concrete questions would probably work better. Lyra, did you have a question you wanted to ask?
Thanks, Megan.
Yes, I did. I am the president of the Foster Parents Association in the Bronx, Rising Ground. Very often I represent foster parents who come up against many of these things, especially the 10-day notice or getting the correct rate for children. I'm actually working with a grandmother in kinship, and the children are so severely impacted, and they've been in care since birth. One just made 10, and the other one is 6 years old. And they do not have regular rate. The rate is so low. I don't even know, thank God the lady works, because she would really not be able to take care of them. And I'm in the process of actually going for a fair hearing for her. And of course, the agency can only go back a year to try to rectify things, but the ball was definitely dropped on this family. And I find that many foster parents too that don't navigate English language well, they're caught up into situations also. And they kind of don't understand, and no one tells you when you become a foster parent that these are your rights, or, so they just, but next thing you know, they're hollering for help, or somebody is saying, can you help this person? And some people have resulted in their homes being closed, and not as a fault of their own. So,
Yeah.
I think, I
They're all
think the
real-
work.
Go ahead, Megan.
I was just
Megan?
going to say those, yeah,
No, I want
those
you to
are-
respond.
those are all real issues. And they are playing out a different way in Monroe County, where, not kinship, but like foster homes are closing because the kids aren't getting the support that they need. And I'm on a board right now dealing with retention and recruitment because it's tough. All of these things lead to so many bigger issues that, like I said, ultimately are stability for these kids. But
I would like to ask one additional, thank you. I wanted to first thank Tara for her question. And I would like to ask those legal representatives on this call, how can we forge that better relationship? What can we do to establish a better understanding? Of course, there's always going to be differences, but if we can minimize the fallout from this kind of miscommunication and understanding, it would benefit the children as well as the family. So how can we do that? Or at least start a dialogue to work towards resolution when it comes to these issues that are brought up today.
yeah, so my hope is that the more that foster parents understand their rights and how to enforce them, it's confrontation, but like it's also kind of you're teaching other people in the system what should be happening, right? So like if more people are appealing to get the exceptional rate for certain reasons, right, for like autism, then hopefully the county will start recognizing that when kids first come in, right? So that we're not going to have these issues in the future. But I do think it's just, keep the coalition's website is great. They actually have a foster parents bill of rights listed on there, and some resources on there. So keep checking that, try to stay up to date, check the resources, and then really don't sit back on your rights. Like you got to be the extra check on that system, and through time then hopefully the other sides kind of learn, and it's not an issue that needs to be fixed after the fact.
Mary, I noticed your microphone is off. Did you want to say something?
Well, I just thought I would echo what Megan said. Sometimes it's hard to find the fine line between being respectful and recognizing that everyone in the system does have, one hopes, the child's best interest at heart, and pushing as hard as you can to make sure that your rights are being recognized and validated. One hopes that the situation Antoinette described, where the judge was just wrong,
Right,
and didn't allow the advocate to speak, is the exception and not the rule.
Right.
Many people in this area of work do have the child's best interest at heart. So it can be very hard in the face of opposition to sort of keep it all together and assert yourself without becoming combative. But
right.
Finding that fine line is key toward making headway. And I think what Megan says is right. You're the person really who's there to educate them about your child too. You know the child best. You're the expert, really. They've only met them in certain circumstances and interviews, and you go in with so much more knowledge than they have. And if you think of it that way, I think it helps. They don't know more than you do about the child.
That's excellent. And Antoinette, I'm not the attorney, but I think if I was in that circumstance, I would have respectfully said to the judge, you are incorrect. I am allowed to speak on behalf of my, I'm an advocate. I'm allowed to speak, And then he says no, but at least you know what's right. Wow, this went so fast. I mean, I can't believe it. It's 12:15 already. Thank you so much, Megan, for taking the time to be with us. Thank you, Mary, for coming as well. It was great for our network to meet you. And as you can tell, the coalition really wants to be more involved in the legal aspect, and you'll be hearing more from us as the year passes on. And I am delighted to note it in her bio is that Megan's going to be on our advisory council. And
great.
it's going to be terrific to have a lawyer on our advisory council who
Excellent.
has the lived experience of being a foster parent. And actually, she's taking care of 2 kids right now as we speak. So,
We're banging pots and
Here,
pans.
thank you, Megan, for your service. And folks, if you think this video was valuable, show it to your network of foster parents. And to be continued. We will always be talking about legal issues. So since our next workshop is at this space at 12:30, Claudia's got to cut us off so she can put us back on. So
Thank you, Megan.
Thank
you very
you.
much. Thank you, Megan.
Fantastic. Thank you.
And everybody have a good day.